Hello, my name is Amanda Stedman. Welcome to BDBF's series of mini webinars on women's health and wellbeing at work in honour of International Women's Day 2025. In today's webinar, I will be looking at rights and protections associated with pregnancy at work. I think it's true to say that the rights and protections for pregnant women at work in the UK are quite well developed, and I've set out the key rights and protections on this slide, and I'll talk through each of them relatively briefly. So looking first of all at health and safety. Employers have special duties to protect expectant mothers at work. They must assess workplace risks to the mother or her baby, and a failure to do so or to act on the findings of a risk assessment may be discriminatory. If an employer cannot avoid or reduce any identified risks, it must alter the employee's working conditions or hours of work if it can do that, and it would avoid the risk. If it's not reasonable to do that, or where doing so wouldn't avoid the risk, the employer has to offer any suitable alternative work that it has available. If there is no such or suitable alternative work, or there is, but the employee reasonably refuses it, the employer has no choice but to suspend the employee on full pay for as long as necessary to avoid the risk. And if the employer fails to pay a pregnant employee while she is suspended, then she will be entitled to complain to an employment tribunal. All pregnant employees have a statutory right to paid time off during working hours for the purposes of receiving antenatal care. In this context, antenatal care is not restricted to purely medical appointments. It can include relaxation classes and parent-craft classes. And separately, the employee's partner also has a right to take unpaid time off to accompany her on at least 2 occasions. An employer may refuse time off to attend an antenatal appointment if it's reasonable to do so, but if it's unreasonable, then they may face an employment tribunal claim, and it may also separately constitute discrimination or detriment in connection with the pregnancy. Pregnant employees are protected from being subjected to any detrimental acts or omissions by their employer in connection with their pregnancy. And detriment here could include things like disciplinary action, adverse appraisals, or demotion. In addition to the general right that employees have not to be unfairly dismissed, a dismissal will also be automatically unfair if the reason or the principal reason for the dismissal or selection for redundancy is for certain reasons, and that includes pregnancy. Where a dismissal is automatically unfair, the employee is not required to have the usual 2 years continuous service needed to bring the claim, and the tribunal will not consider the reasonableness of the employer's actions. In other words, if pregnancy is established as the reason for the dismissal, the employee will win the claim. And don't forget that any such automatically unfair dismissal may well also be discriminatory. And on that, women who suffer pregnancy and maternity discrimination will be able to bring claims before the tribunal. And they can do this if they are subjected to unfavourable treatment during what is known as the protected period. The protected period starts when the pregnancy begins and ends at the end of the 52-week maternity leave period, or earlier if the employee returns to work before then. And also from the 1st of January this year, pregnancy and maternity discrimination protection was extended to cover unfavourable treatment which occurs even after the end of the protected period, if that treatment was because of the pregnancy or a pregnancy-related illness which occurred during the protected period. Some common situations that we see which give rise to pregnancy discrimination are in the following areas. So firstly, recruitment. Employers need to take care not to ask job applicants whether they are pregnant or plan to have children. It would be discriminatory if an employer declined to make an offer or withdrew an offer on the basis that it discovered the woman was pregnant. And similarly, it would be discriminatory to dismiss a woman for not having disclosed that she was pregnant during a recruitment process. Also, in connection with promotion, employers need to take care not to discriminate against pregnant employees, for example, by not telling them about a promotion opportunity or discouraging them from applying, or by refusing to appoint because the employee is pregnant. And employers also need to take care in respect of processes such as performance management or sickness absence management. If the reason for the poor performance or the sickness absence is connected to the pregnancy, any subsequent action may be discriminatory. Pregnant employees who are at risk of redundancy also have priority status for any available suitable alternative vacancies ahead of other employees, including those who may be better candidates for the role. And that protection starts on the day that the employee informs her employer of her pregnancy and ends on the day that the statutory maternity leave starts, albeit note that the priority status does also continue separately through the maternity leave. If a pregnant employee is made redundant without having been offered an alternative suitable vacancy, the dismissal will be automatically unfair and may also be discriminatory. Now, looking ahead, the Labour government says it plans to legislate to make it unlawful to dismiss pregnant employees in certain circumstances. And this proposal appears to go further than the existing protections against dismissal that I've just outlined. The suggestion appears to be that even if there is a fair and non-discriminatory reason for dismissal, it could still be unlawful, subject to some limited exceptions which are yet to be determined. So I think we can see that the law is quite advanced in terms of rights and protections for pregnant workers. So what more can you do as an employer to support pregnant staff and make their working experience the best it can be? Well, there are obviously lots of things you can do, but I've pulled out 4 practical pointers that I think are helpful. So first of all, train your line managers. Well, in fact, all staff need training on equality law and on the importance of not discriminating or harassing pregnant women at work. But I think it's especially important for line managers to know how to respond to notifications of pregnancy and understand the risks of pregnancy-related detriment and discrimination. The fact that a job applicant or employee is pregnant should not be something which influences a manager's attitude towards them or their decision-making. And yet it still happens. A good example of this was seen in the recent case of Smith and Greatwell Homes, where an employment tribunal concluded that the reason the employer had excluded an employee from a recruitment process for a new internal post was because the positive view that managers once had of her was, and I quote, eroded by the knowledge that she had become pregnant. In another case, Ship and City Sprint Limited, after informing colleagues that she was pregnant, a senior employee was asked a number of highly inappropriate and intrusive questions from various senior executives. Such questions concerned when she had stopped using contraception, if her pregnancy was planned, if she'd thought about how her pregnancy would affect her long-term career prospects. And it was also alleged that the CEO had remarked that they should put a wager on how much weight Mrs. Ship would put on during her pregnancy. So training for managers is key. Secondly, I think it's really important to respond to the initial notification of pregnancy in the right way. Get things off on the right foot by following the notification of pregnancy. Don't leave the employee hanging or having to chase you for a response. Respond in a timely way and respond in a comprehensive way, addressing all the important issues that the employee needs to know about. So things like how and when you're going to conduct the risk assessment, the entitlements to antenatal appointments and how they should notify you about an appointment. And of course, the entitlements to maternity leave and pay. Thirdly, I think it's important to make sure that any pregnancy-related sickness absence is managed correctly. It should be recorded separately and not counted for any absence management purposes. And be mindful of what you can do to help an employee who is absent for pregnancy-related reasons. So, for example, could you offer some sort of flexible or home working arrangement, because this may assist the employee and help avoid the need for further sickness absence. And my final practical pointer is to make sure that you meet with the employee in good time before they go on maternity leave, as well as getting things off on the right foot, make sure that the employee departs in the right way as well. So meet with them and discuss with them issues like how they need to hand over their work before they leave, how their work will be covered while they are away, how much or perhaps how little they want to stay in touch with the company while they are absent, and obviously make sure that their wishes are respected. That's all from me for today. Tune in tomorrow when I will be looking at the topic of maternity leave.